Hi friend, welcome to the Company Law Education and Appeal Series. Today we are discussing a Northern Western Regional Director Appellant Order in the matter of the Vallabha Industrial Chemical Engineers Private Limited and its Director against the Gujarat ROC adjudication order for the violation of section 12 subsection 1 of the companies, where regional director reducing the penalty to the 50% of the total penalty imposed by the Gujarat ROC. Let's see the case. In order that applicant made an online appeal under section 454 subsection 5 of the Companies Act in form ADJ against the Gujarat ROC order dated 7th July 2021 passed by the adjudicating officer of Gujarat. On receipt of the appeal, the directorate while later dated 20th September 2021 forwarded the appeal to the ROC Gujarat for its comments in the matter. With the reference to the aforesaid letter of the ROC, Gujarat has submitted its report on 5th October 2021. Thereafter, the matter was finally fixed for hearing on 30th March 2022. Facts of the case: the ROC Gujarat, in exercise of the power vested with the him under section subsection 3 of section 454, White order dated 7th July 2021, and pursuant to the following violation of section 12 subsection 3 C of the Companies Act, in the penalty imposed as under on the scheduled date of the hearing, authorized representative of the company and its director in default appear and attend the hearing, submitting therein that the company is duly complying with the section 12 subsection 3 C and has already printed its name, register office address, scene, mail ID and letterhead, but due to oversight, graphic designer made mistake in the printing, also didn't counter check carefully in this matter after getting it printed. The company accepted its inadvertent mistake occurred as these letterheads are newly printed and mentioning of the scene on its forgotten. It is concluded that the company and its director in default are liable for penalty as prescribed under section 12 subsection 8 of the Act for committing default under section 12 subsection 3C during the period 27th January 2020, letter issued by the letter dated 27th January 2020 issued by the company to Mr. VC and Associate Chartered Accountant, attached with AD 2 to 12th February 2021, date of the first notice issued to the company for intimating default for the provision of section 12 subsection 3C. Accordingly, penalty of the rupees 1 lakh has been imposed on the company and 1 lakh each on the every director who is default for the violation of section 12 subsection 3C. The company and its director have filed the present appeal under the provision of section 454 subsection 5 of the Companies Act, challenging the order made by the adjudicating officer. By the impugned order, the adjudicating officer, in purported exercise of the power, has adjudicated and imposed penalty on the company and its official default for violation of the provision of section 12 subsection 3 C of the Companies Act. That the applicant have submitted in their petition that the company has prepared two letters dated 27th January 2020. That is, one was original and one was office copy. Due to clerical mistake of the office, the office copy was delivered to the VC and Associate, which was not having seen due to printing mistake at the bottom of the letterhead. Further, office copy was just formal inward in the records of the company and not for circulation or communication to outsider. The appellant failure for not mentioning seen on the letter due to clerical inadvertent mistake was complied within 15 days. The company held a board meeting and passed a board resolution for removal of the auditor. The extract of the board resolution is having seen printed on the letterhead with suffix requirement of the section 12 subsection 3C of the Companies Act. Directors are not from legal background and hence they had to fully rely on the expert consultant who has skipped to advise company on day-to-day compliances, and therefore company by mistake posted office copy instead of the original letter having all the details as per the section 12 subsection 3C of the Companies Act. During February 2021, the director of the company were engaged in the medical emergency, and in those critical days the director were not in position to reply well within time to the adjudication notices. See, this is on and such a sudden and untimely and sad demise of the director come family member took present directors into heartfelt sorrow, and such a condolences period was not appropriate to reply well by the resident directors. ROC Gujarat, an education officer, has submitted his reply reiterating that the company has filed e-form ADT1 and attached letter addressed to the ROC Ahmedabad regarding urgent appointment of the new auditor in place of existing auditor, in which company has also failed to mention its sin on its letterhead as per the requirement, with tantamount to penal action under section 12 subsection 8 of the Companies Act. Adjudicating officer ought to have appreciated that the ignorance of law cannot be an excuse. For the hearing on appeal has been conducted on 30th March 2022. ROC office has not attended the hearing, and authorized representative of the company was present in the hearing and reiterated the submission made in the appeal. Having considered facts and circumstances of the case and submission made by the appellant in appeal and request of the authorized representative made in the hearing on the appeal, regional director of the opinion that penalty imposed by the adjudicating authority be reduced to 50% considering the financial position of the company and being a small private limited company. Accordingly, 50,000 has been imposed on the company and its applicant director with a direction to strictly comply with the required compliances under section under Companies Act 2013, and here reduced penalty on the company, that is 1 lakh to 50,000, that is reduced, and on the officer in default, that is reduced to 50,000 on each instead of the 1 lakh on each. Thank you so much for watching this update.